case is captioned State of Iowa versus Willard Miller, FACR 005143. Personally present today is Jefferson County Attorney Chauncey Molding and Assistant Attorney General Scott Brown for the state. The defendant, Mr. Miller, is present with his attorneys Nathan Olson and Christine Branstead. Counsel, I've been informed that a plea agreement has been reached between the parties and the defendant wishes to withdraw his previous not guilty plea and enter a guilty plea pursuant to the plea agreement. And at this time, I'll allow either any attorney to recite the terms of the plea agreement for the record.
Judge, I can do that. We have entered into a written plea agreement with the defendant, Willard Miller. The defendant is going to plead guilty to murder in the first degree. The recommendation by the state is that our plan, at least at this point, is to recommend a minimum sentence of 30 years and a maximum sentence of life with the possibility of parole. The defendant, since he was under the age of 18, is not subject to the mandatory minimum sentence in a Class A felony of life without the possibility of parole. However, he is subject to the mandatory minimum under certain conditions pursuant to Iowa Code Section 902.1 sub 2. This will be a guilty plea. This is not what we normally would term an offered plea. He will make a factual basis to the elements that are set forth in the plea agreement. Unless the court wants me to recite what those elements are, I know you're going to do that later. But there is an accomplice liability theory of aiding and abetting, which is incorporated into those minutes of testimony. It's the same accomplice liability theory that would be incorporated into the elements and marshalling instruction that we would have given to a jury in Pottawatomie County. That is the basics of the plea agreement. There are other conditions that are listed in that written document. We have a signed version of that by all parties, and our intention is to upload that into EDMS at some point following this hearing.
And either Mr. Olson or Ms. Branstead further comment at this time?
Your Honor, that is a correct recitation of the plea agreement.
And Mr. Miller, you've just heard the state's attorney and your attorneys talk about the plea agreement. Is that your understanding of the plea agreement?
Yes, Your Honor.
And is it your personal desire to accept this plea agreement and proceed to plead guilty today to the crime of murder in the first degree in violation of Iowa Code Section 707.2?
Yes, Your Honor.
I am required by law to personally advise you of your rights and determine if you are pleading guilty because you are in fact guilty, and I'm required to make sure there's a factual basis for your plea. So I'm going to ask you a series of questions. If at any time you don't understand any of my questions, interrupt me and I'll go over it with you again. Also, at any time you can talk to your attorneys before answering any question that I ask you. You understand that, Mr. Miller?
Yes.
And if at any time you don't want to continue with this plea of guilty, you just let me know and I'll stop. Nothing you'll have said up to that point can be used against you at trial. Do you understand that?
Yes.
Mr. Miller, how old are you?
I'm 17 years old.
And how far have you gone in school?
I graduated freshman year.
Do you have any trouble reading, writing, or understanding the English language?
No.
Are you presently under the care of a doctor, psychiatrist, or psychologist?
No.
Are you under the influence of any alcohol, drugs, or prescription medication?
No.
Are you a United States citizen?
Yes.
Are you presently on probation or parole?
No.
other than this case, do you have any other charges pending against you?
No.
Have you received a copy of the trial information?
Yes.
And have you had the opportunity to go over that document and the charges against you with your attorneys?
Yes.
And have your attorneys explained the charges against you?
Yes.
And do you understand the charge, and specifically for today, murder in the first degree charge?
Yes.
Attached to the trial information are the minutes of testimony, and those are the statements of what the state's witnesses would testify to at trial concerning the charges against you. Mr. Miller, have you read that?
I have.
And have your attorneys gone over those minutes of testimony with you?
Yes.
As a general proposition, do you agree with the statements of the state's witnesses in the minutes of testimony as it relates to charge of murder in the first degree? And Ms. Bryant said if you want to interject, you can.
Your Honor, there is, for the most part, my client would stipulate to the minutes of testimony. I think there is one particular statement with which he does not agree, but agrees that the court may use those minutes of testimony in determining whether or not his factual basis is sufficient today.
And Mr. Miller, do you agree that I can use the minutes of testimony in this case in determining a factual basis for your plea today?
Yes.
And is the state agreeable to that?
We are, Your Honor.
There are certain essential elements of the crime of murder in the first degree that you're pleading guilty to that the state would have to prove beyond a reasonable doubt to a jury or a judge if you decided to not have a jury trial. I'm going to ask either Mr. Brown or Mr. Molding to recite the essential elements for the record.
The 4 elements of first-degree murder, as they're stated in the plea agreement, is that true, Judge?
Correct.
All right. The elements of murder in the first degree, as listed in the plea agreement, again, this would have been in the marshalling instruction to the jury should this have been tried. The first element is on or about the 2nd day of November 2021, the defendant struck Nohema Graber or aided and abetted Jeremy Goodale in striking Nohema Graber. The second element is that Nohema Graber died as a result of being struck. Element number 3 is the defendant acted with malice aforethought or aided and abetted Jeremy Goodale, who acted with malice aforethought. And the fourth element is the defendant acted with premeditation, willfulness, deliberation, and a specific intent to kill Nohema Graber, or aided and abetted Jeremy Goodale, who acted with premeditation, willfulness, deliberation, and a specific intent to kill Nohema Graber.
Mr. Miller, you understand the state of Iowa would have to prove all of those essential elements beyond a reasonable doubt to the satisfaction of a jury or judge in order for you to be convicted of murder in the first degree?
Yes.
And do you understand by pleading guilty here today that you're admitting to all of those essential elements of the crime?
Yeah.
And keeping in mind that the court will not permit anyone to plead guilty who claims to be innocent, what is your plea to murder in the first degree, guilty or not guilty?
Guilty.
Mr. Miller, in order to accept your guilty plea, I must be convinced that there is a factual basis for the plea. Now, we discussed that I'm allowed to consider the minutes of testimony in considering the factual basis, but I also need to have you recite what you did on or about November 2nd, 2021 that leads you to plead guilty to this charge. And I'm going to have your attorneys assist you in this factual plea or factual basis at this time. Ms. Branstad, would you like to ask your client some questions regarding?
Mr. Miller, will you agree that on November 2nd, you were in Jefferson County at Chautauqua Park?
Yes.
And were you with Jeremy Goodale at that time?
Yes.
Did you act as a lookout while Jeremy Goodale struck Nohema Graber?
Yes.
Did you know that Jeremy intended to kill Mrs. Graber?
Yes.
Did Mrs. Graber die as a result of being struck?
Yes.
And was it your intention, at least at that time, to help Jeremy Goodale kill Mrs. Graber?
I did intend to assist him. Yes.
And knowing that that was your intention, would you agree that that was acting with malice aforethought and that your acts were premeditated?
Yes.
Does the state have anything further?
Judge, just to make sure we round out the facts in this case, and these would all be in the minutes. It was our intention at trial that the evidence would be that Mr. Miller planned the murder of Nohema Graber, that this plan was in place with Jeremy Goodale. They both acted, both as principals as well as aiders and abettors in the planning of the death of Nohema Graber. It's also the facts that are in the minutes that Mr. Miller, Willard Miller, struck Nohema Graber with the bat. We also have evidence that Jeremy Goodale did that as well, that they both acted together in doing that and bringing about her death. So those facts are there in the minutes. There's also additional facts that detail the planning, the cover-up, the destruction of evidence. Those things are in the minutes as well, which also support his plea that he acted with malice aforethought and acted with premeditation and specific intent to kill.
Ms. Branstad or Mr. Olson, do you want to make a further record on the issue of the factual basis?
Your Honor, I believe that my client has provided sufficient factual basis. I would note that my client denies that striking Mrs. Graber, but other than that, I think he's in agreement with the majority of the minutes of testimony, which are additional indicia of premeditation, but I believe his factual basis is sufficient at least for today's proceedings.
And counsel, everybody agrees that based on the minutes testimony and Mr. Miller's statements about the premeditated malice and intent to kill Nohema Graber, that there's a sufficient factual basis that Mr. Miller committed murder in the first degree in Jefferson County, Iowa on or about November 2nd, 2021. Is that correct?
Yes, Your Honor.
Mr. Miller, is that correct?
Yes.
And is the state satisfied with this record?
Yes, Your Honor.
Mr. Miller, have you fully and completely discussed the charge filed against you and the matter of your plea here today with your attorneys?
Yes, I have.
And Ms. Branstad or Mr. Olson, have you discussed the existence of any possible defenses with your client?
Yes, Your Honor.
And other than a general denial, do you know of any defense that could affect the outcome of this case?
Your Honor, there are other defenses that we have discussed with our client. with regard to ability to form intent and his capacity at the time. We have discussed those both with our client and with potential witnesses, and Mr. Miller agrees that those are not viable defenses for him.
Mr. Miller, are you satisfied with the representation your attorneys have given you in this case?
Yes, I am.
And defense counsel, have you fully advised your client of his constitutional rights, and are you willing to defend him at trial if you wish to go to trial?
Yes, Your Honor.
Mr. Miller, have any threats or promises other than the plea agreement been made to get you to plead guilty?
No, Your Honor.
There are certain rights that you give up by entering a guilty plea. I'm going to go through those with you right now. If you continued in your plea of not guilty, you'd be entitled to a speedy and public trial, 12 people, and their verdict must be unanimous. You'd also have the right to waive a jury trial and have your case decided by a judge if you wished. By pleading guilty, you're waiving your right to a trial, and there will not be a trial of any kind. At trial, you would be entitled to have an attorney represent you, and if you couldn't afford one, one would be appointed for you. At trial, you'd have what's called the privilege against self-incrimination. That just means you could not be required to testify against yourself. At trial, you also have the right of confrontation, and that is that the names of the state's witnesses on the minutes of testimony would have to come into court, take an oath on the witness stand, testify in front of you, be subject to cross-examination by your attorney. You also have the right to subpoena witnesses on your behalf and compel their attendance, even if they did not want to voluntarily attend and testify. At trial, you're presumed innocent until the state proves, if ever, that you're guilty beyond a reasonable doubt. Mr. Miller, you understand by pleading guilty today, you are waiving all of those legal and constitutional rights that I went through.
Yes, I do.
And is it still your desire to waive or give up the rights we've gone through and enter a plea of guilty today?
Yes, Your Honor.
There are also maximum and minimum penalties associated with the crime of murder in the first degree. It's a Class A felony. There is a maximum sentence of life in prison. There is what I think the sentencing hearing will consist mainly of is there's a range of potential minimums that the court can set. There's not a automatic life sentence without the possibility of parole because you were a juvenile when this act occurred. So regarding mandatory minimums, there's not that automatic mandatory minimum. But you could face some sort of sentence of incarceration before you would see the parole board. There is a requirement that you submit to a DNA sample. There is also on cases where someone is found guilty or pleads guilty to being responsible for another's death, restitution in at least the amount of $150,000 pursuant to Iowa Code Section 910(3)B. In this case, you would be jointly and severally liable for restitution and potentially other costs. There could be no contact orders as well entered in this case. There's no fine. Mr. Molina or Mr. Brown, regarding maximum and minimum penalties for this Class A felony, and given the defendant's age, Is there anything else do you think I need to add for maximum and minimum penalties?
I think the court has mostly covered it. Obviously, he's not subject to the mandatory life without parole. It is our intention to recommend a minimum sentence of 30 years pursuant to the plea agreement. Of course, the court will have to apply the factors, not only in the case law that we will cite to you at sentencing, but also pursuant to Iowa Code Section 902.1 sub 2. But I think you have stated what the mandatory minimum, at least agreed to in this case as far as what the state can recommend. The defense is free to recommend any sentence that they feel is warranted by law or by the facts. So I do believe that that rounds it out.
Is there any further record on a mandatory maximum and required minimum penalties from your perspective, Ms. Branstad?
Your Honor, given that my client is juvenile, I believe that even a deferred judgment would be available. I have reviewed the parameters of a deferred judgment with my client as well.
And Mr. Miller, have you reviewed the document that you and the state's attorney have come up with for a plea agreement?
Yes, I have, Your Honor.
And actually that probably goes over the mandatory and minimum sentences. I tried to summarize it here for you. Do you have any questions or misunderstandings of what could possibly happen regarding sentencing at your sentencing hearing?
No, Your Honor.
You do understand the possible maximum and minimum penalties that I've just described to you?
Yes, I do.
Okay. And Mr. Miller, I also believe it's my obligation to tell you that a plea of guilty may have other adverse consequences, such as the loss of ability to vote, possess firearms, or receive federal or state benefits. And keeping in mind everything we've just discussed, Mr. Miller, and all the rights you are waiving, do you still wish to plead guilty to the charge of murder in the first degree in violation of Iowa Code Section 707.2?
Yes, I do.
And just for the record, I believe since part of the factual basis, or at least the instructions or the plea involved an aiding and abetting theory, that Iowa Code Section 703.1 would also be part of today's guilty plea. Counsel, any other record that needs to be made or anything that I've left out of this guilty plea that could affect the validity of this plea?
Judge, you just mentioned the accomplice liability theory, which is charged in the elements. I'm not sure I quite caught the code section you mentioned. Did you say it was 703.1?
703.1 is aiding and abetting. Is there any other code sections that you wanted me to cite?
No, I was just making sure I had that the number reference on the code was correct. I appreciate that. Thank you.
Okay. Any further record on that issue from the state?
No, Your Honor.
Counsel, for the defense, anything I've left out of the record that could affect the validity of the plea?
Your Honor, within my checklist, I may have missed it, but I have advised my client that any verdict would have to be unanimous and that the court is not bound to the plea agreement but could sentence my client to up to the legal maximum.
And Mr. Miller, do you understand that I am not necessarily bound by the plea agreement, and I can sentence you in accordance with the law in a way that's less favorable than the plea agreement.
Yes, Your Honor.
That's a possibility. Anything else, Ms. Branstad?
Your Honor, you may intend to address this at the end, but the plea does involve giving up certain appeal rights. Under the current law, any plea of guilty and stayed within the plea agreement, any appeal would be as to sentence, but not as to the validity of the plea or his guilt.
I will touch on that a little bit later. It's, I've got it down on the list a little bit further. So, counsel, is there any reason why the guilty plea of the defendant should not be accepted?
No, Your Honor. No, Your Honor.
No, Your Honor.
It is a finding of the court on the record made that the defendant is acting voluntarily. He understands his rights and the consequences of his plea, and there is a factual basis for the plea as made. The court therefore accepts the defendant's plea of guilty to the charge of murder in the first degree in violation of Iowa Code sections 707.2 and 703.1. Mr. Miller, I must inform you at this time that pursuant to the plea agreement, that there's you're waiving your right to challenge the guilty plea. Am I stating this right, counsel? So usually there's a motion to arrest a judgment where you can decide at least 5 days prior to sentencing, but no later than 45 days from today's date, that you wish to withdraw your guilty plea. But is it my understanding, counsel, that Mr. Miller wishes to waive his right to challenge this guilty plea that we're having right now?
Your Honor, may I have 1 moment?
Yes.
Your Honor, my client does not intend to challenge the guilty plea and certainly has waived his right to appeal the guilty plea other than, well, the guilty plea in any manner. May I speak to counsel for a moment? Your Honor, I don't believe waiving the motion and arrest of judgment was within the guilty plea, and perhaps I missed that. I certainly see no reason why my client would intend to waive his motion and arrest of judgment, but I believe that is still a viable option for him if there was an irregularity in the plea proceeding.
Judge, if I may try to clear this up.
Okay.
So part of the plea agreement, which I didn't recite earlier, it's obviously a bit lengthier than I had mentioned. I gave the basics earlier. Part of that plea agreement is in paragraph 10 of the document that we'll be filing, that should the defendant appeal, the parties agree he may only challenge the sentence and not the guilty plea or conviction. This agreement does not concern post-conviction relief. Those terms were agreed upon by both the state and the defense last week whenever we were finalizing this agreement. I think that clears this up.
Okay. And Mr. Miller, mean to make this more complicated than it might already be, but I am required, because if you're not waiving your right to file a motion to arrest the judgment, I need to inform you of your right to file a motion to arrest the judgment. And that is your only avenue for challenging this guilty plea prior to sentencing, which must be filed no later than 45 days from today's date, and in no case later than 5 days prior to the date and time set for sentencing. A failure to raise challenges in a motion to arrest the judgment precludes or waives your right to raise those challenges on appeal. And I understanding that if things go the way that it looks like they're going to go, that at a certain point you do forego your right to appeal the guilty plea, but that would be after sentencing. If you have further questions on that, I would talk to your attorneys in between now and sentencing. And we will, counsel, go into chambers to try to look at our calendars to set a sentencing hearing. There's not a for pre-sentence investigations on an A felony are not required, or was there any discussion of that?
Say that again, Judge, I'm sorry.
For an A felony, PSIs are not required, or I didn't know.
Under these circumstances, it may be, because there is some discretion with regard to the minimum sentence, so I think a PSI under these circumstances would be warranted. We have not discussed that, but the only time when it's not is when the sentence is a mandatory life sentence without the possibility of parole, which we do not have here.
And it is my inclination to order a PSI, even though it's a murder in the first degree. Normally, that doesn't happen. So, is there any objection by the defense for me ordering a PSI?
No, Your Honor. In fact, my client has started the biography and is prepared for the PSI interview.
Okay. So the court also orders a pre-sentence investigation be prepared by the 8th Judicial District Department of Corrections, and that report be filed no later than 3 days prior to the date and time set for sentencing, to be made available to counsel, the defendant, and the court. The defendant is not eligible for bond pending sentencing. Is there anything else we need to discuss on the record today, counsel?
No, Your Honor.
No, Your Honor.
Okay. That concludes the record. Thank you.